It all began when Karen decided she had the right to roam freely across my ranch, despite repeated requests to stay off my property. I had installed a new fence a few months earlier to clearly mark the boundaries, and for a while things seemed fine. That is, until Karen decided to test the limits. One morning, I received a frantic call from the HOA office. Karen was claiming I had illegally blocked access to her property, citing some convoluted clause in the HOA bylaws. She threatened to sue me unless I removed the fence and allowed her to cross my ranch at will. I sighed, recognizing the pattern. Karen had always been audacious, but this was a new level. She didn't know one very important fact. I was a retired attorney with decades of experience handling property disputes and HOA litigation. I knew the laws inside and out, and she had no legal standing on my private land. The next day, a process server showed up with court papers. Karen had filed a lawsuit claiming unlawful obstruction of access. I accepted the papers politely, all while keeping a calm smile. As I read through the complaint, my mind ran through all the defenses and counterclaims I could file. Trespassing, harassment, and even abuse of the HOA's authority were just the beginning. I responded formally, laying out the law clearly. The fence was entirely within my property boundaries. I had provided multiple warnings, and Karen had repeatedly trespassed in the past. My counterclaim included demands for damages for the stress and inconvenience caused by her actions, as well as a formal injunction preventing her from entering my property without permission. Court day arrived, and Karen strutted in with the confidence of someone who thought she had it all figured out. I quietly reviewed the case file, prepared to let my decades of experience do the talking. When the judge called the case, I stood and presented the facts succinctly. Your Honor, this is a matter of basic property rights. The defendant owns the land in question, as evidenced by the recorded deed. The fence is entirely within those boundaries. The plaintiff, by repeatedly trespassing and demanding access without legal authority, has violated not only property laws but the terms of the HOA itself. We respectfully request that her suit be dismissed and that damages be awarded for her repeated harassment. Karen sputtered, attempting to interject, but the judge swiftly reminded her of courtroom decorum. When the HOA's attorney tried to argue on her behalf, it became clear they hadn't reviewed the deed or the local statutes, basically leaving Karen to argue her case alone. After hearing all the evidence, the judge ruled decisively in my favor. Karen's lawsuit was dismissed, and the court issued a formal injunction against her entering my property. On top of that, I was awarded damages for the stress and disruption she had caused over the months. Her face went pale, and she muttered something under her breath as we left the courtroom. From that day on, Karen avoided my property entirely. The fence remained, standing proudly as a symbol of law, reason, and patience prevailing over arrogance. HOA meetings became much quieter for me, too. Neighbors seemed hesitant to repeat her mistakes when they saw the legal precedent clearly established. The incident became something of a legend locally. People would whisper about the retired attorney who not only defended his ranch but completely turned the tables on a notoriously aggressive HOA member. And as for Karen, she was never quite the same, her confidence replaced by caution, at least when it came to trying to boss me around. In the end, it wasn't just a victory for me. It was a reminder that knowing your rights and standing your ground can completely change the dynamic with even the most overbearing neighbors. My ranch remained peaceful, my property secure, and Karen learned, the hard way, that crossing a retired attorney on his own land is never a smart idea.